Those of you who are just joining us, remember, headphones, earbuds, everything's out, phones off in the way for the duration. We're lucky enough to have Superior Court Judge Michael Cahillane here, so I'm going to open up the presentation. He can start, and then after he's done giving you his intro, let's ask the good questions that we created and have a nice, robust discussion. So, welcome.
Good morning, everyone. My name is Michael Cahillane, if you want the real Irish pronunciation. So, just to let you know my background, I've been a Superior Court judge since December of 2023. Prior to that, I worked for the Bristol County District Attorney's Office. I was assigned to the Superior Court prosecuting major felony cases. I was assigned to oversee all investigations in Fall River involving non-fatal shootings, and I was also assigned as a member of the homicide unit. So I worked prosecuting a number of the murders that took place here in Fall River. Before I came to Fall River, I was an assistant district attorney out in the western part of the state, out in Franklin County and Hampshire County and Northampton, up by where UMass Amherst is located. And I worked there for 10 years, started out in the district court, which handles misdemeanor cases and some felony cases, and I worked my way up into the Superior Court prosecuting major felony cases there as well. Prior to becoming a lawyer, I attended St. Anselm College, and then I attended Suffolk Law School at night. I was working full-time. So the reason I ended up in Fall River is I ran for district attorney in Hampshire and Franklin counties and didn't win. So it was quite a humbling experience to lose an election and to something you pour your heart and soul into. And after the election, then District Attorney Sam Sutter called me and asked me if I would come to Fall River and join the Bristol County District Attorney's Office, which I did, and turned out to be a great career move for me. So I tell you that story because I'm sure as you know, there's going to be lots of bumps along the way, and there's things that you're going to run into that things don't go your way, but just want to let you know that there is definitely, when coming out of those very difficult situations, that it does get better. So the education piece, I worked with a lot of people at the Bristol County District Attorney's Office who attended Durfee High School and went on to college, went on to law school. So is there anyone in the group who's interested in going to law school? All right. So what have you started looking at to figure out how to get into law school, how to prepare for it, what to do?
Well, Fall River has youth court that I'm involved in, so I read the whole experience today just to make sure that it's actually the field that I want to pursue. And then I'm a senior, so I've already started applying to colleges and going back.
Okay, great. So for those of you who don't know, typically the path is 4 years of college, and then law school is generally 3 years. I went at night, worked full-time, so it took 4 years to get through law school. And then I went to work for the DA's office after that. So it is quite a longer process to get through that. And when I was in high school, I wasn't exactly sure what I wanted to do. I was a politics major at St. Anselm. I was looking at a lot of different careers, but I ended up doing an internship with the DA's office at the time, and that's really where I found my interest in the law and the interest in working as a prosecutor. I worked closely with the State Police Detective Unit, who was assigned to the District Attorney's Office, so that was a way where I kind of found my footing. And then after college, I looked around and I actually worked in healthcare for a while and did something completely different. And then when I was in law school, changed things back to the criminal justice side of it interests me more than the healthcare, and that's how I ended up back in the DA's office. So it's, in college, there's a lot of people who study different things, figuring that they want to be lawyers. My wife is a lawyer also, and she was an English major, which has proven to be very fruitful for her because she's an excellent writer. So she's part of our job now as judge. I'm responsible for writing decisions on cases. So typically what happens is when a case comes into the Superior Court, and I'll back up a little bit to the way that cases get to the Superior Court, is we are a court of general jurisdiction, which means that we can pretty much hear any type of case that comes up. So we are the only court in the Commonwealth that can handle first-degree murder cases. They can only be heard in the Superior Court. We handle all controversies over $50,000, and we also are able to hear equity claims. So I'll get into that a little bit later, but that's our general jurisdiction of the cases that we hear. So criminal cases come into the Superior Court by way of presented to a grand jury, which is people who are from the community who come in. Instead of getting called for regular jury duty, they get called for grand jury, and they would sit for 3 months at a time. They listen to evidence that's presented to the grand jury, make a decision as to whether there's probable cause to believe that a crime was committed, and there's also probable cause to believe that this is the person who committed the crime. So it's a screening process that cases move from the district court up into the Superior Court. The civil cases, so that's how criminal cases come in. How civil cases come in is the filing of the lawsuit. So someone can either do it, well, the term is called pro se, meaning that they're representing themselves, or they can be represented by a lawyer. They would file a complaint with the court. That gets filed, basically alleging what the facts are. A lot of times it could be someone's hurt in a car accident, someone's at a store and slips and falls. It's a contract dispute, a business dispute, a real estate dispute. So those types of things are filed with the court, and then what happens is to ensure that people have due processes, the other side is required to have notice of it. So that there's a notice that goes out, it's called summons, that lets the person know that they're being sued, gives them a chance to answer the complaint, to be able to kind of respond, to defend themselves, and then the case progresses through the system by way of discovery, which means just getting all the information, figuring out what's out there, and sharing it with the other side, and then eventually the case is brought to a resolution by way of a settlement on the civil side, or by way of a plea on the criminal side, or the case could go to trial. So one of the biggest rights that we have as citizens is to be able to have a right to a jury trial. So that right goes back to the founding. I'm sure a lot of you are studying history, so that it goes back to the founding of our country, that the way that things used to act when we were a British colony is that the king would control, and the king would just order things to happen, and that the government would do things. But this changed when our country started to be able to have a right to a trial, to be able to put the dispute before fellow citizens and have them make a decision as to what the facts are, and be able to apply the law as the judge instructs them. So there's a lot that takes place for a case to go through the court system. I'm sure that you see in your studies, there's times when it takes years for cases to get through to an end. So that typically is the reason why, because there's a lot of steps that have to go through. We have to make sure that there's protections along the way for people when they come into court. So one of the things that we ensure is that people have representation if they're entitled to it, to have lawyers appointed to them so that they can be assisted by a lawyer. So Mr. Brownell has represented a lot of people. He's been a court-appointed lawyer, and a private attorney has been able to represent people. So the court would appoint somebody who is indigent, meaning that they don't have the funds to pay for it themselves. So that way we can ensure that people who need it have quality representation when they come in to the court system. So the things that we want to make sure from our end is that as judges that we preserve an independent judiciary. And what I mean by that is that we're not swayed by popular opinions or by any outside pressures, that we make a decision based on the law and based on the facts that are there. So I know that some of the questions that were put out there too is people go, how do you make that type of decision? And a lot of that's based on research and looking at the case law and making a determination. So the way that cases, after they go through the district court or the superior court, can be appealed. So there's two appellate courts in Massachusetts. One is the appeals court, one is the Supreme Judicial Court, and they review our decisions and they make sure that we're applying the law correctly, so that if people, if they've gone through the system and don't feel that something was handled appropriately, it can be reviewed by an appellate court. And then when the appellate court reviews it, they issue a decision and they're applying the law for that particular area. So it's always changing in some respects, but it all goes back to the Constitution and the rights that were put out in the Massachusetts Constitution, which served as the framework for the United States Constitution. So that was drafted, original draft by John Adams. If you learn that in your class, a little bit of history for you. So there's a lot of ways that cases can come in. Has anyone had to go to court before? Not as a defendant, but if you had the opportunity to go and to just observe a court. Okay. So our courthouses are open. They're a public building. You can come in at any point. You can come down to 186 South Main Street to the Fall River Justice Center. And on the 4th floor is the district court. On the 5th floor is the superior court. You could come in anytime that the court is open and just come in and observe. So typically on the 5th floor, there are 4 different courtrooms up there that are simply for trial. So there's a trial that's happening there every single day, whether it's a murder case, whether it's an assault case, whether it's a robbery, or there's also a session that handles all of the pretrial matters, motions to suppress, motions to dismiss. And so anytime you could walk in and see what's happening. Yes, ma'am?
Do you have to, is there any age requirement to go inside the trial?
I'm sorry, I couldn't hear you.
Is there any age requirement to go inside the trial?
An age requirement to
observe.
To observe?
Yeah.
No, you can come in, so we can arrange something too with the class to come in and spend time there and observe what's happening. And we try to be aware. There are younger students that come into the court, so we try to be aware of that, and certainly you're all older, so we try to make sure that it's appropriate for the type of trial that's happening. So unfortunately, a lot of the cases that take place at the Justice Center involve sexual assaults and child sexual assaults. So they're not the cases that you really want to sit in and listen to. A lot of the testimony is graphic. It's very difficult to hear, but the experience of going and observing and watching what happens, I would certainly encourage it, and we can make arrangements to have you do that if anyone's interested in that.
So I know you said like the Superior Court can take in like any cases because general jurisdiction and things like that, but I was wondering, because I feel like that's a lot of law to go into like one person's brain, so I was wondering if like judges focus on certain like aspects of the law when like for the cases that they take, or if it's like you guys have to know everything.
Well, it's an excellent question. So, over the course of my legal career, I was a prosecutor the entire time, so I was focused on criminal cases only. I had some background on the civil side. Like I said, I worked in healthcare, so I had some exposure to that. When I was appointed by Governor Baker, I was initially put into a civil session. And so it was a completely new area for me, and I felt like you did, I felt like I was back in school, because I literally had to take out the books, and in my, it's called the lobby, it's my office that's off of the courtroom. There are, all the law books are in there for all the statutes, all the case decisions, and also everything's online too. I can also just bring it up on my laptop. But I literally had to if there was a motion that was filed asking for some type of relief, or there was a hearing that was coming up or a trial that I was preparing for, I literally would break out the books and spread them out in front of me, break out the rule books, and just look and see. So I've had to teach myself a lot of the civil side of it. Part of what we do in the Superior Court is we also have judicial mentors. So I work with another judge who has been on the bench for a long time, that she's available to me at any time to, if I have a question, to be able to reach out to her. I also have all of my other colleagues that I can reach out to if there's an issue that after I've researched it, I want to get other opinions on, get other people's thoughts on it, that we could do that. We could reach out to them and ask them. I was in the middle of a medical malpractice trial. It was a wrongful death case where a woman was suing her doctor, claiming that he had done something wrong that led to her death by failing to diagnose something. And while we were having what's called our charge conference, which I sit with the lawyers and go over the law that the jury's going to be instructed on to make sure everything is covered as to an explanation of all of the elements of the claims and what they have to apply. And the defense attorney said to me, "You can't do that. You're going to destroy the way that medical malpractice cases have been tried for the past 30 years that I've been doing this." And so I said, "Okay, appreciate your argument. I'll take it under advisement," which is the key part of our job, is taking something under advisement, which means that we can step off the bench, go into our lobby, and look it up. So it's kind of like an open book test at that point too. We can always, whatever issue is there, we can step back, research it, make sure that we're confident and correct in our decision. And I put out an email to two of my colleagues who I knew that before they were put onto the bench, that's all they did. They only did medical malpractice cases. And I sent them an email, said, "This is the situation I have. This is what they're claiming. This is what I'm planning on doing." And within about 2 seconds, one of my fellow judges sent an email back saying, "What phone number are you at? I'll call you right now." And called me and said, "Nope, you're absolutely right. That's the way that they're doing it. They're testing you. They want to make sure that they want to see how you're going to handle it." So that happens too. Some of the attorneys like to push the envelope and try to get away with push things as far as they can. So that was one of those situations. So as I've pretty much been in civil sessions, I've been in a few criminal sessions, but primarily civil. So a lot of it is going back and learning, but we also do a lot of judicial education conferences. So the other judges that are specialists in certain areas will teach. So we're actually, next Wednesday, I believe it is, that we'll be at UMass Law in Dartmouth. There's a whole group of the judges that get together that we have an hour-long training where half of 45, or it's actually an hour and a half, 45 minutes is on civil topics, 45 minutes is on criminal law. So we're always learning, keeping up to date, and keep fresh with all the case law that comes down. The other thing that we get is typically every single day during the week that the appellate courts that I talked about will issue their decisions. So I get an email Monday through Friday at 10 a.m. from the appellate court saying, "These are the decisions we've made today." And as soon as that hits my email, I need to open it up, review it, keep myself up to date of what the most current law is. Sometimes it's a 2-page decision, sometimes it's a 151-page decision. So it's, there's, the joke is among the lawyers that are the judges in the district court. One of my good friends who I worked with for a long time is a district court judge. She said that at the end of the day, we're leaving at 4:30 and carrying our lunch boxes, and you guys in the Superior Court are walking out carrying your homework. So we're always having to work at night, work on weekends to keep up with everything that's going on. So it's definitely not a 9-to-5 job. Yes? Absolutely. So there's a few that from when I was working here in Fall River, there was a murder case that I prosecuted that unfortunately took a long time to get through the court system because there was different lawyers that had changed representing the defendants in the case. And also, as we were gearing up for trial, COVID hit. So the courts were shut down for about 2 years where no trials were taking place. You can imagine the backlog, that there's cases that are still happening, that people are still being charged with crimes, cases are still coming in, but we weren't able to try any cases, so things got backed up. So we had a real push once things lifted after COVID to get first all the murder cases tried and then move on to the serious felony cases. So there was a case here in Fall River where a young man who went to schools here in Fall River was walking to his girlfriend's house, that he ran into 2 of his old pals that he used to run with, that they thought that he had snitched on them on a prior case when they got caught with ammunition in a car after being chased by the state police. And as soon as they saw him, they recognized him. His 2 former buddies pulled out guns and began to shoot at him. They fired 21 shots. One of the shots went through his back, came out through his chest. He was able to run several blocks, running down behind St. Anne's Hospital. Almost made it to the emergency room. He collapsed out behind the hospital and passed away there. So it took a lot of investigation to figure out who the perpetrators were and to bring the case through the grand jury and to get the case to trial. And both of those young men were convicted of first-degree murder and are both serving life sentences at this point. The young man who was killed, his family from Portugal, his parents were older, and I was concerned because of the delays that happened in the case, whether they were going to make it to the trial because of health issues that they had as well. But they were able to see the case through and to be able to have some sense of justice after the case was finally resolved. But that's definitely one case that has stayed with me.
I know you spoke briefly upon how you approach interpreting the Constitution as a judge, but how do you ensure the Constitution relevance to modern cases?
Well, I didn't catch
How
that
do you
part.
ensure the Constitution is modern relevance to modern cases?
So there's in Massachusetts with the SJC issues decisions, they're always interpreting, like I said, and they're issuing decisions that we're bound to follow as trial judges. So when we are applying our own common sense to the decisions and reading them, and then having to apply the facts of the particular case to it to make sure that the rights of, could be any type of case where you have, say it's a case of ineffective assistance of counsel, where a case is being brought back before you because the person has been convicted of a crime, they're claiming that their lawyer was ineffective, didn't do the job that they were supposed to do. So there's certain standards that you have to review and look at the performance of the lawyer, to look at what happened during the course of the trial, and then to be able to see whether the rights of the individual person were protected. So it's changing in some respects, but there's usually a big pattern. One of the big things that's happened recently that you may have seen is there was a case that came down from the Supreme Judicial Court, which is Commonwealth versus Matz, which changed the way that juveniles were sentenced if they're convicted of murder. So there has been a tremendous amount of study that has been done on juvenile brains and what is called now emerging adults. So people like yourselves. And the research that has been done is looked at studying medically, looking at MRIs, looking at other forms to be able to examine people's brains and see how they develop, and also to study people individually to see how they are. So as a teenager or a young adult, what the research has shown is that until you're 26 years old, that your brain is not completely developed. So that typically what that means, and I'm sure all of the female students will agree with me, that high school boys, young adults are prone to do impulsive things, are prone to do dumb things, and a lot of times that can get them into trouble when it's a dumb, impulsive, criminal thing that they do. So the studies that have been looked at have really shown that is something that can be quantified, that the brain isn't fully developed, so that those bad decisions that I made back in high school and that I'm sure many of you have made, that they are not an excuse but an explanation for certain types of conduct. So the way the law was is that if you were over 18 years of age and you were convicted of first-degree murder, that you were sentenced to the term of your natural life. That's the language that the clerk reads at the sentencing, that you were sentenced to the term of your natural life in the Massachusetts Correctional Facility. What this case, Commonwealth versus Mattis, they spent a lot of time working with the research, working with particular cases involving young adults and applying that medical side to it to say that, yes, you can still be convicted of first-degree murder. However, that group of young adults between 18 and 21 are entitled to see the parole board. Doesn't mean that they're necessarily going to be paroled, but when you're sent to prison, there's another group, part of the executive branch, the parole board, that reviews your particular case to see whether you have redeemed yourself, whether you have been rehabilitated. And that's the whole goal, is for people to have rehabilitation. And they found that having a life sentence without the possibility of parole for this group of individuals between 18 and 21 was unconstitutional. So it's changed the law drastically for people now to be able to have the opportunity to see the parole board. Good. I thought you were raising your hand too. Okay.
How did you feel about overturning
It's,
I'm sorry, can you say the question louder?
How did you feel about the overturning the vote you made?
I won't get into my personal comments on it, but I can tell you that certainly in Massachusetts that things are different than they are in a large portion of the country, that there's certainly other protections that are built in here legislatively, where the governor took actions to protect access to reproductive rights, and then also the legislature took action. So as you'll see in some other states, that there's cases that are brought to challenge restrictions that are placed on reproductive rights. And I think that the rights here are very strong, and that I think it would be very unlikely that a challenge to them would affect that.
So like when you were talking before, it just reminded me of the idea of like restorative justice, in the sense that like the justice system is like justice system that is meant to get people, rehabilitate people and get people back into like the working world. So like I guess my question is like, how do you feel about that, and what do you think the justice system, like the Superior Court and just like the justice system as a whole in America, like what do you think its role is in regards to restorative justice? If it has
A lot to unpack there. So the district court, typically what happens when people come into the district court, so I don't know if you know, I'll just give you a brief overview. Say someone's arrested for breaking in, that they are caught by the police arrest them, bring them to the station, book them. They have to type up a report explaining what the facts are that support probable cause to charge that person. That person would then be brought to the Justice Center. The complaint would have to be put before a clerk magistrate who reviews it to say, yes, there's probable cause to believe that crime was committed, this is the person who committed it, and then the complaint issues. Then that person's brought into the district court, they're arraigned, meaning that they're brought before a judge and publicly the charges against them are read to them, and it's determined whether they're going to have a lawyer appointed to them, whether they're going to represent themselves, and that's how the process starts. Typically in the district court, the focus there is to help people. A lot of times is try to identify kind of what got the person to that particular point to be charged with the crime. So is it they're homeless, they were stealing to a loaf of bread for something to eat? Do they have a substance abuse problem? Do they have a mental health issue? Is there something there that the system can work to help them at that point? So really, the focus in the district court, there's a number of, they're called specialty courts that have started that are there for substance abuse, that as opposed to being incarcerated, that you can agree to go into this program and to be closely monitored, to receive intensive treatment, to basically comply with it. So it's to get the person help on that front. There's also mental health courts that are working with people to try to address any of the mental health issues, to keep them where they're seeing a therapist, where they're receiving inpatient treatment, where they're receiving their medications, anything of that nature. There's also veterans courts, where if a person's veteran, they have experienced some type of trauma when they were serving the country, that there's a focus there also to get them help on that front, to be able to address that specific area. So really in the district court, that focus is there all the time. The probation officers who work in the district court are always working closely with their clients to make sure that any of their issues that they have are addressed. So that really is the focus of the district court. There's people obviously who are sentenced to jail out of the district court depending on their record, what their criminal history is. You know, for someone who this is their first time into the system, that there's always that focus to get the person help and try to identify the issue. The things change as people's behaviors escalate. So if you have someone who goes from breaking in and stealing something in a house, or going rummaging through a car and stealing change out of the car, to breaking into someone's home when they're there and assaulting the person in there, or having a weapon, or carrying a gun, or something of those nature, things get ratcheted up. So typically the people that we see in the Superior Court on the criminal side, it's not their first rodeo when they've made it. That they've usually, it's very rare that someone commits a very serious felony crime right from the jump to end up in Superior Court. So in the Superior Court, there is still a focus, and there's certain people who are there to rehabilitate, to get services, but the other end, you have the carrot, you have the stick, and the stick on the other side is state prison. So that is always a potential for people when they come in. And there are, in Massachusetts, we have what are called sentencing guidelines, so it's not left really to, there's a lot of discretion by the judges involved in sentencing, but there's also guidelines, so you have a range of sentences that are typically imposed.
How do you feel about the restrictions or lack of restrictions?
Hold that question for 1 second, because I just realized I didn't answer your ultimate question, which was on restorative justice. So a lot of that restorative justice takes place in the district court primarily, where there is an agreement for a victim in a case and for a defendant in a case to basically sit down, and it's almost like a mediation, to be able to kind of hash out, let the victim the opportunity to explain how this crime has affected them, and then also for a defendant to explain kind of how they got to that point as well too. And a lot of the things that we see along the way that with criminal defendants is that they've had some trauma in their life as well. So a lot of the people that we see in the court system are people who lived in a home where there was domestic violence. They've lived in a home where one of the parents had a substance abuse issue. So those traumas build up. So these things don't happen in a vacuum where people just become a bad person. That there's usually things that are identifiable along the way where you can see how the person got to this point and then try to work with them to rehabilitate them. So the restorative justice piece is actually recently was introduced into the Superior Court as well, and there's a model that's being developed to implement that. And there's actually a number of inmates at the correctional facilities who are instrumental in bringing that in, that they've wanted to be able to have that ability to apologize, to be able to meet face-to-face with the victims, to talk to them and to really explain the sorrow that they feel for what they did, and to be able to try to reconnect and to heal that piece of it. In court, the victims have a right. There's a victim's bill of rights that victims are entitled at the time of sentencing to address the judge and to be able to give what's called a victim impact statement, where the person can talk about how this crime has affected them, what it's done to them, any physical pain, mental pain, any issues, they can share that with the judge. So that's something that's taken into consideration during sentencing. But this would be interesting to see how the restorative justice piece in the Superior Court works, but it's definitely something that's coming shortly. So back to your question on gun laws. So part of my job in the DA's office, that I was in charge of the firearms unit. So any gun crime that was committed in Bristol County, I oversaw the prosecution of those cases. So Fall River, New Bedford, Attleboro, Taunton, all the other towns in Bristol County, any gun crimes came through me. Massachusetts has some of the strictest gun laws in Massachusetts. There's requirements that you have to go through in order to obtain your license to carry or your firearms identification card to show that you are the term is suitable person to be able to have your license. Over the 23 years that I was a prosecutor, it was extremely rare. I can think of probably 2 instances where gun crimes were committed by people who were licensed gun owners. One was an incident actually that happened here in Fall River. The guy was mad, his girlfriend started dating someone else and he shot up her house. So a very drastic response to a breakup. But it stands out of my mind because it's very rare that you have people who are licensed carry. Typically what you will see is people who get access to guns, and a lot of times it's done in the area of people who are involved in drug distribution, that it's used either to intimidate somebody or to protect the operation, if you will. So the laws in Massachusetts are written in a way that if you carry a gun, either on school grounds, that you carry a gun outside on the street, that the legislature has made the determination that you're going to jail. That's the bottom line. You're going to serve not less than 18 months in the House of Correction. If you are convicted out of the Superior Court for a first offense, you're facing a maximum 5 years in state prison. That's just for possessing. So that doesn't mean if you shot at somebody, that doesn't mean if you threatened somebody with it, that's just for tucking it in your pants and walking around with it. So there's an escalation that happens as well too. So if you are involved in drugs or you like to beat people up and get in fights and you're convicted of certain crimes, in Massachusetts we have what's called the Armed Career Criminal Statute, which means that if you are caught with a gun or with ammunition, and you have either a prior conviction for a serious drug offense or for a violent crime, that you could be sentenced for your first possession not less than 3 years, not more than 10 years in state prison. If it's 2 of those prior crimes, then it's not less than 5, not more than 15. And if you're not bright enough to get it after that, and you come back for a third time, it's a minimum sentence of not less than 15 years in state prison, not more than 20 years in state prison. And so there's also offenses for if you threaten someone with a gun, if you shoot at someone and you miss, you shoot at someone and you hit them. There's other assault crimes that go along with it. But the gun possession laws in Massachusetts are very strict. One of the other things in Massachusetts that works is you're also required to lock your guns up. So if you are a gun owner, that you're required to have a safe, you're required to have a disabling device, whether it's a cable lock or something else, to secure your gun so someone can't get access to it. And there's also escalating penalties as well if you allow your gun to be accessed by someone who is not trespassing, meaning by someone who's living in your house, or where there's a minor living in the house too. There's an enhanced penalty for that to make sure that people who own guns keep them safe, because we see most of the gun crimes that happen are guns that are stolen, guns that are bought in other states with less restrictive gun laws and brought into Massachusetts to commit crimes with. And also now we're seeing what you probably heard you refer to as ghost guns, which are guns that are, when they're purchased, they're only 80% complete, and then you can buy the components to build them and to make it a working firearm. And I can tell you that I have spent, since I was a young boy going to the range with my dad, I've been around guns a lot, and you know, personal life and professional life, and I can't imagine building a gun on my own and then having the chutzpah to pull the trigger after I build something like that. But that's a lot of what we're seeing now, is guns that are these ghost guns that are being built. So those are being targeted right now by the legislature to put in specific provisions for those guns as well, for the building of those particular weapons.
Was there any case that made you create firearms?
So the verdict piece of it is, so what happens is when we have a case that comes in and goes to trial, that we have what's called a verdict slip, which is where on a civil case the jury has to answer a number of different questions. Was Joe Smith negligent when he left a broom laying across the floor at Home Depot and somebody tripped over it? What were the damages that were part of that? What did the person suffer in that particular case? On the criminal side, it's the person charged with murder is Joe Smith, not guilty, guilty, and then the jury returns their verdict. It's read in open court so everyone sees it. It's not done in any back room. It's open and put out there. So typically on a civil case, the jury is the one who's making the determination as to what the damages are, what the person's injuries are, what the monetary compensation will be for their injuries. On the criminal side, with the sentencing piece of it, that's where there's the discretion to it. So there are certain cases, like I said, with the gun cases where it's not less than 18 months. As a judge, the legislature has said, you don't have discretion in this area. You cannot sentence someone to less than this amount. And you can't sentence them to more than this amount. So there's a range on every crime that's out there. So the difficulty and the challenge for us is fashioning something that addresses all of the issues of the crime. So you have someone, the punishment is a legitimate part of the system. That is something that is recognized, that if you commit a crime, you're going to be punished. But with that being said, there's also the other pieces of it too, the rehabilitation piece. So a lot of times what you see is in sentences is individuals who are sentenced to a term of incarceration, whether it's on the county side for the House of Correction in Dartmouth or Ash Street in Bedford, or to the state prison. But there's also a component of probation afterwards, where the person's going to have to report to the probation officer. They're going to have to check in every 2 weeks. They're going to have to remain drug or alcohol free, they're going to have to find a job, they're going to have to continue their education. So there's those sides of it to try to make sure that people who are coming out of incarceration, it's very difficult. Obviously, you've been on the street for 3 years, 5 years, 10 years, 15 years. Life changes, and hopefully they've taken advantage of the programs that are in the Department of Correction. There are education programs. You can get your college degree while you're there. You can learn skills. It's certainly not like learning here. It's a very different environment, but that's a big piece of it afterwards to get people educated and get people working so that they're not out on the street, not getting themselves involved in situations. So that's why I'll preach it. I'm sure your teachers preach it every single day. That's why education is so important, because it opens doors to you to be able to get certain jobs, to be able to do certain things. So without that education, you're really going to hamstring yourself. So yes.
We have a question up here. They want to know the most difficult decision, or what are the most difficult decisions that you make in your position as a judge?
So really the sentencing piece of it, determining what is an appropriate sentence, because you really have to balance, recognizing that a criminal defendant is a human being, that they're a person, that recognizing the fact that, like I talked about earlier, that most of them have had some type of trauma in their lives as well that have brought them to that point. And then also to balance that you have a victim or a victim's family that's lost their son, that they've had their life turned upside down, to be able to find that balance of the appropriate amount of punishment, putting together a plan for rehabilitation where the victims in the case are satisfied, but also the defendants understand the magnitude of what they've done. So that's probably the most difficult piece, is finding that balance. And it's very difficult because it's a very emotional piece where you're dealing with people's lives. So that's the most difficult side, I would say. Yes, sir.
I'm not sure if you can answer this, but what is your thoughts or interpretation on death penalty?
So in Massachusetts, we haven't had the death penalty in a very long time. And it was, in talking with victims' families, and unfortunately I've prosecuted a lot of murder cases and had to sit with families who have lost a loved one, whether it's their son, their grandmother, multitude of situations. So that when people lose someone like that in a violent way, most people's reactions are that they want vengeance, not justice. So what I tried to do was to be able to explain how our system works, how the sentencing structure works, and to be able to explain that if someone who's convicted of murder in the first degree, which is murder with either deliberate premeditation or extreme atrocity or cruelty, or during the course of a felony murder, that that person is, if they're convicted in first degree, they're going to go for life. That there's no chance of them getting out unless the governor commutes their sentence. And like I talked about earlier, there's some people, if you're convicted of second degree murder, or if you're an emerging adult, that you can have the opportunity to go for parole. So there are those things. In talking with the families who have lost loved ones in those cases, that after talking to them about the system and how everything works, that most of them are satisfied with that and are understanding that they don't want the death penalty to be imposed, because I think they feel a certain sense of pressure on themselves, that even though they've lost a loved one, they don't want to feel like they're taking someone else's life as well.
I don't know if you can answer this, but how do you interpret states taking someone else's life? Do you think it's constitutional as they're exercising their rights and checking the executive branch, or do you think it's unconstitutional?
Say it one more time.
How do you interpret states taking off Trump off the ballot? Do you think it's constitutional as they exercise their rights?
Well, we'll see now that the Supreme Court has agreed to hear that, so they'll be the ones to decide whether whether it's something that is in the rights of the states to be able to do that and to be able to make a finding that he engaged in insurrection or insurrective conduct, and that they're entitled to take them off as part of the state's rights, or whether it's something that they're going to say it should be put to the people and that they should be allowed to vote. So that's, with that being a pending matter before the Supreme Court, that I'm sure they'll make a pretty quick decision on that, so we'll know fairly soon.
As someone who just like do you think it would be like constitutional for a president to be able to pardon himself?
That's a very interesting question that's out there too on the issue of presidential immunity, whether that the president has the right to do certain things under the guise of acting within rights. It's also a hot topic issue that I'm sure you've probably heard, that kind of goes into the areas of police brutality and those issues that were raised there in the term of qualified immunity. So qualified immunity deals with police officers or other state employees doing things in the course of their career and making certain decisions, taking certain actions that you're protected from being sued. So it was put into place to try to protect people, you're not getting sued every day for just doing your job. So there's some people who think that that's gone too far, that certain people are protected too much by that, and that they're allowed to basically run roughshod over people's rights with that type of protection. So that is an area that is being looked at now by the legislature, and also would be definitely subject to interpretation of whether that qualified immunity stands, or whether people are going to be protected. It certainly isn't a situation that you want to protect. It's just not to pick on police officers, but bad cops. You know what? I unfortunately also prosecuted a number of police officers who stepped outside the law and did something wrong. So that, as a prosecutor, my job is to enforce the law no matter who the other person is. And everyone's equal under the law. You don't get some benefit just because of your rank or the job that you have. So
We have about 5 more minutes.
okay.
Okay.
So that piece is, so people who go beyond that, who intentionally break the law under the guise of their authority, they're going to get prosecuted. So we have seen some of the cases that have happened here in the city and other places as well too. So I spent a lot of time working with police officers, spent a lot of time, I joke with my wife that I probably spent more time with the detectives here in Fall River than I did with her a lot of times, when getting called out at 2 o'clock in the morning for a shooting or for a murder that happened. So I know from working closely with law enforcement for 20 plus years that the police officers don't want that kind of scene. They want these people rooted out that are doing bad things. So, any other?
What was your favorite subject of law study?
Criminal law. That was really, that what got me back into it. In law school, you have so many areas that you're studying. You're studying constitutional law, you're studying property, you're studying contracts, you're studying, and like I said earlier, all those things I have to study again now. But criminal law was my favorite subject, because I think there's a real practical sense to it that's easy to apply. Yes.
After like being a prosecutor so long, how do you, if you do, like how do you not get jaded, I guess, hearing all these, especially hearing a bunch of murder cases and things that are kind of like hard to listen to, how do you like, I guess, stay passionate about what you do?
You have to compartmentalize certain things that it took me a while to be able to try to let things go and to try to leave it when I got home, because there's horrible things that happen out there. You don't want to bring them home. So I tried to keep it out of my house and just leave it at the door when I walked in. But there's things in the state it's difficult work. It's very, if you want to do it right, you have to be passionate about it. You have to pour your heart and soul into it. You can't half-step that, because victims demand that you give it your all, the community does, so you pour yourself into it. So being able to separate it, be able to take breaks, and be able to have good colleagues that you work with that you can share the experiences you're going through, and be able to talk it through and try not to bottle it up.
I guess maybe just one last thing. For anyone in here who is thinking about going into law or having a legal career, any words of wisdom or pieces of advice you would give them on their journey as they work towards that?
Study hard. It's challenging work. That it is. It's a lot of research. It's a lot of writing. It's so pay more attention in the English class than I did, and it'll be very helpful for you for your writing side of it. But that get out there, go and come to the court and come see it. And see it up close and personal. And I'm happy to, if any of you want to come. I'm actually sitting in Brockton now, so if any of you come up to Brockton, I'm in the Brockton Superior Court. But if there's any of you that want to come to the court here and see what's happening there, I'm happy to make those arrangements to get you there when there's an interesting case that's going on, and be able to see it start to finish, to see lawyers make their opening statement, to give their closing argument. It's really incredible to watch when people are good at this. There's certain people who are excellent, that have honed their craft, and that when you hear their closing argument, it's like watching a movie, that really you are drawn into it, you feel like you're there, you can picture everything that's happening, and it happened in the course of that case in your mind. So I would encourage you to do that.
Thank you, Judge Cahillane, for taking the time out of your day. Ladies and gentlemen, you're going to advisory, so please just